All of the information that is discussed in this video is derived from the total market capitalization per coin. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this Ripple versus C comparison right now. Finally, we have returned with a notice of supplemental authority that has been filed. Ripple and the United States Securities and Exchange Commission (SEC) have been involved in a drawn-out legal dispute that has been going on for more than 3.5 years. In the most recent turn of events, the United States Environmental Conservation Agency (SECA) has drastically decreased its demand for a penalty from $2 million to $102 million to $102 million. In spite of this, Ripple has decided to decline the offer made by the SEC and has instead submitted a notice of supplementary authority as disclosed by defense attorney James Phelan earlier. On July 2, 2024, Ripple submitted a notice of additional authorization to the United States. Court of Judge Alyssa Torres received a notice of supplemental authority from Ripple Labs, which was provided by the company itself. The significance of this lies in the fact that it is connected to Ripple's opposition to the sexist motion for remedies and final judgment. In light of Binance's recent success in court, Ripple is challenging the methodology of the Securities and Exchange Commission (SEC). The company asserts that formal rulemaking is necessary because the SEC's procedures do not adhere to standardization and clear rules. Ripple stressed in the statement that intangible digital assets do not conform well to the limitations provided by the 7-page rule known as the Howey test, which determines what constitutes security. The Howey test is a test that establishes what constitutes security. Ripple was opposed to the plan from the Securities and Exchange Commission (SEC) to regulate the industry through the use of court cases. Ripple said that this method would result in inconsistent decisions and provide market players with uncertain guidance. The AKS anticipated that the SEC would make reference to the ruling in SCVV Terraform Labs as part of their anticipated reaction to Ripple's notice of additional authority. The judge, Rakoff, came to the conclusion that Terraform Labs had broken the United States Securities and Exchange Commission's law by neglecting to register. Additionally, Judge Rakoff brought up the decision regarding the programmatic sales of XRP, which gave the impression that Judge Torres may have made a mistake in her decision. It is predicted that the resolution of this legal action will have a significant impact on the price of XRP, which is Ripple's native token, as well as on the greater cryptocurrency market. This is because the outcome of this legal action will have an effect on the price of XRP. An increase in the value of XRP would be triggered by a victory for Ripple, just as it was the case after Ripple achieved a partial victory the previous year. In the opposite direction, a victory for the SEC can result in a drop in the market for cryptocurrencies. With Ripple's recent submission of a supplemental authority notice, a new stage in the ongoing legal fight between Ripple Labs and the U.S. Securities and Exchange Commission has begun. Ripple submitted this notification to Judge Alyssa Torres on July 2, 2024, in support of its decision to deny the Department of Securities and Exchange Commission's request for a resolution and final judgment. The recent judicial trial that Binance went through is cited by Ripple as evidence in favor of its assertions that the regulatory technique employed by the SEC is inadequate and that relying entirely on court cases to exercise control over the cryptocurrency business inevitably leads to unpredictable outcomes. There is a standard securities framework known as the Howey test, and Ripple mentioned in its filing that cryptocurrencies do not readily comply to this structure. Additionally, the 7-page verdict brought to light the enforcement action approach of the Securities and Exchange Commission (SEC), as well as the absence of explicit regulatory regulations, legal interpretations, and confusion for market participants. The fundamental strategy that Ripple employs is to demand that the Securities and Exchange Commission (SEC) reconsider its regulatory posture with regard to cryptocurrencies, as well as the future of the legal process in light of the SEC's counterarguments. It is anticipated that the Securities and Exchange Commission will be able to contradict Ripple's notification by emphasizing its victory in the litigation brought by Terraform Labs, according to Judge Rakoff's ruling. The failure to register terrorists in Luna as securities Terraform was their fault. This ruling could establish a precedent in favor of the Securities and Exchange Commission's hostility to Ripple if Duquan had, in fact, violated American securities laws. In addition, Judge Rakoff expressed skepticism on Judge Torres' inclusion in the discussion regarding XRP's standing, which brought up doubts surrounding the programmatic sales ruling. However, the outcome of this lawsuit will have a significant influence not just on the price of XRP, but also on the entire cryptocurrency market. If XRP is awarded by the SEC, its value may decrease. But what if Ripple is victorious? XRP's price can experience a sizable increase as a consequence of this. Continuing legal battles with the Securities and Exchange Commission are being supported by Ripple Labs and Coinbase, which are using a recent court verdict against Binance as evidence. Following the dismissal of the legal dispute with the SEC, both companies filed appeals for enhanced regulatory standards related to the Binance case. These appeals were made in response to the case. Binance's motion to have the SEC's case dismissed in the subject at hand was, for the most part, refused by Judge Amy Berman Jackson of the United States District Court for the District of Columbia. She rebutted the charges that Balance Coinbase was offered in secondary markets as securities and argued that the Commission ought to adopt a legal model that is based in the United States. In its appeal to the Court of Appeals for the Third Circuit, Coinbase cited the decision made by Binance as support. In the petition, Coinbase argued that the WC need to campaign for uniform and open laws similar to those that are found on Ripple and another cryptocurrency platform. It would appear that for detailed legal standards throughout these judicial actions is being driven by the industry's desire to maintain stability within a well-defined legal framework. The landmark court that Binance established, known as Victory, is being utilized by Coinbase and Ripple Labs in order to dispute ongoing claims that are being brought before the United States Securities and Exchange Commission. Both companies argue that formal rulemaking is required in order to further define the regulatory perimeter for digital assets, and that the approach taken by the SEC has to be more uniform and unambiguous. When referring to Binance v. CC, Coinbase and Ripple cite a recent court verdict that was made about Binance. This ruling resulted in a partial dismissal of the SEC complaint that Binance had filed. Ripple Labs and Coinbase have both increased their efforts to defend themselves in court. This precedent, according to the businesses, demonstrates the need of the Securities and Exchange Commission (SEC) establishing specific rules. In a recent court filing, Ripple brought attention to the judge's conclusion that Bitcoin does not entirely fit to the securities standards that are currently in effect, such as the Howey test from 1946. The process of determining whether or not a transaction satisfies the conditions to be regulated as a securities contract and whether or not it is thus subject to securities law. The cryptocurrency exchange Coinbase has concurrently voiced its concerns regarding the Securities and Exchange Commission of China's SEC's expansive interpretation of securities legislation in relation to the cryptocurrency industry. This debate makes the argument that this broad application could be defined more specifically and made more thorough in an effort to bring about greater clarity in the legal proceedings. Additionally, it promotes the notion of a final regulation method. For the purpose of bolstering its appeal and bolstering its argument for rulemaking, Coinbase cited the recent order that Binance issued, which it claimed highlighted the differences in the regulatory applications that are already in place. And in its interactions with a wide variety of cryptocurrency assets and platforms, the Securities and Exchange Commission (SEC) has classified a significant number of their activities as securities offers that have not been properly registered. In the case of Ripple, the Securities and Exchange Commission (SEC) submitted a complaint in December 2020, asserting that the company had collected more than $1,330,000 through the sale of its XRP coin, which it had classified as an unregistered security. A decision made by Judge Annalisa Torres, which took an unexpected and dramatic turn. Nevertheless, there were certain programmatic sales of XRP that did not meet the criteria for being considered securities transactions. Ripple is currently attempting to utilize this verdict to refute more broad CC allegations, which introduced a nuanced understanding that was introduced by this ruling earlier. Coinbase is also subject to the monitoring of regulatory authorities.